Hello everyone, my name is Jordan Morton and my co-presenter is Kayla Clark. We are students at Washburn University's School of Law and will be talking with you today as part of the Children and Family Law Center about how the Strengthening Families model can help attorneys make more ethical decisions. This presentation is one of 6 in this project. We will be referencing some of the other topics in our presentation today, and you can find all of the other presentations on the Children and Family Law Center website. Attorneys have a tremendous amount of power in family law cases. Attorneys can make decisions that are more in line with their ethical obligations by adopting a Strengthening Families model of advocacy. This presentation posits attorneys can better advocate for their clients and reduce trauma-inducing outcomes by adopting a model of advocacy that promotes the strengths of an individual family. As a result, attorneys will make decisions that are more in line with their ethical obligations to their clients, which we will explore in more detail. During this presentation, we will discuss the Strengthening Families model, the different actors in family law cases, the impacts of the Strengthening Families model on attorneys' ethical obligations, and how attorneys can use the model to better advocate for their clients. Let's start with a basic overview of the Strengthening Families model. Our colleagues have put together an entire presentation on this subject, and we recommend watching that for a more in-depth discussion of this topic. But for the purposes of this presentation, all you need to know is that the Strengthening Families model is a highly structured, evidence-based family skills training intervention with different age versions from 0 to 17 years of age. The graphic on the screen shows 5 protective factors that research indicates can reduce childhood trauma. These factors are enhancing parental resilience, providing parents with concrete resources in times of need, supporting healthy social and emotional development in young children, facilitating knowledge of parenting and child development, and providing an array of social connections. This approach seeks to increase family strengths, enhance child development, and reduce the likelihood of child abuse and neglect. Evidence has demonstrated that outcomes for at-risk families are improved when things such as these protective factors are in place. This can be crucial for helping families reduce trauma and make it through the adversity that they face in their lives every day. Throughout the presentation, we ask that you keep this hypothetical situation in mind to evaluate how the Strengthening Families model we are discussing can impact the results of a family law case. Jane is a single mother of 2. She works multiple part-time jobs and the children's father is not in their life. Jane depends on family members and friends for childcare. A friend from work noticed that Jane seemed to be more stressed in recent weeks and asked her what was going on. Jane responded that she had been let go from her other job because the company couldn't survive the pandemic and she was becoming concerned about how she was going to make ends meet. Jane's friend gave her some pills to help her relax. At first, Jane only took them at night before she went to bed, but over the course of many months, Jane began taking the pills more frequently to help her deal with stress. Now she feels like she has to take them just so she can function. Jane's children usually stay with Jane's mother until she gets off work and is able to pick them up. The children's teacher have commented to Jane's mother that the children show up to school in the same clothes they wore the day before and sometimes go days without bathing. One teacher noted that Jane appeared to be completely checked out during a recent parent-teacher conference. During a particularly challenging week, the children arrived to school extremely late, if at all. On the 3rd day in a row that this happened, one child told his teacher that, "Mommy has been sleeping all day, so she can't bring us to school." The teacher called for a welfare check to Jane's home, and the responding officer found Jane passed out on the couch. When she awoke approximately 4 hours later, she appeared to be severely impaired. The officer made a hotline report to DCF and has taken the children into police protective custody. So what happens next? Likely, a child in need of care, or a SINC case, as they are known in Kansas, will be opened. A hearing will be held to determine if safety concerns will require that the children be removed from the home. Another option involves the children's father. If he is able to be found and notified, and he is willing and able to assume parental responsibility, then he might be given custody in lieu of opening a SINC case. If the children's father comes back into the picture, the case could only exist in domestic courts, which has significantly fewer resources to offer directly to this family. In the alternative, there are options that don't involve the court too. The Department of Children and Families and their contractors, such as KBC and St. Francis, can work directly with families to provide services that would help the family meet its needs through programs such as family preservation. However, given the facts of this hypothetical, it is possible that the children would not be allowed to remain in the home with Jane at this time. Why should we care what happens to Jane and her children? The harm of separating families is very well documented in social science research and literature. The current precedent set out in Cinque Court and high conflict custody litigation can create a trauma-inducing response for these families. This presentation argues that adopting a strengthening families model approach when dealing with these situations can decrease the level of trauma experienced by all involved. Take Jane's case as an example. Separating the children from their mother vastly increases the likelihood of severe negative outcomes for these children. Jane is currently experiencing difficulties in taking care of herself and her children, but with the help of services like substance use treatment, she can do so adequately. Under a strengthening families approach, we would recognize that the children are bonded with their mother and that removing them should be an absolute last resort if there is any way for this family to remain together safely. One way to keep this family together would be to find substance use treatment options that allow for Jane's children to be with her during the process. If Jane's children have to be removed, placement with family should be explored before placing the children in a traditional foster home, away from everything they've ever known. On the surface, this may not seem like something that Jane's attorney would or should be involved with, as social workers are the ones who primarily deal with connecting a family to services. Attorneys are generally not employed for preventative measures in family cases. However, once attorneys are involved, their decisions will impact how the family is viewed, which in turn will determine the actions taken throughout the life of a case. Under the strengthening families model, all actors, including attorneys, should be working to decrease trauma. Looking at the strengths of each parent involved is a great way to start. There are many different actors involved in family court and child welfare court. These actors include parents' attorneys, guardians ad litem or GALs, agency attorneys, judges, social workers and CASA volunteers, and mediators. Each of these actors can promote the strengthening families model in their work with their clients, children, and at-risk families. The role of a parent's attorney, whether in a custody or a Cinque case, is to pursue the goal established by the client according to Kansas Rule of Professional Conduct 1.2a. The American Academy of Matrimonial Lawyer Standards view parents' attorneys as instrumental actors in maintaining harmony and protecting children from malevolent parental behavior. This standard amplifies the importance of attorney's role, as the lawyer must take into consideration the impacts actions on behalf of their client may have on the children involved. For example, if there is a history of domestic violence between the parents, the attorneys may advocate for a variety of services, such as supervised exchanges, in order to reduce the number of situations where the parents have to directly interact with each other. This follows the strengthening families model because it allows for the children to still have a relationship with both of their parents, but does provide adequate protection from the conflicts that exist between them. In civil domestic cases, such as divorce or parentage, there is no legal right to counsel. Many parents end up representing themselves in domestic issues because they cannot afford an attorney. Parents do have a constitutional right to an attorney in Cinque cases and will be appointed one by the court if they cannot afford one. Whether an attorney is representing a parent in a Cinque or a domestic case, the attorney is ethically obligated to pursue the goals of their client. Guardians ad litem are often called GALs for short. GALs are automatically appointed in every Cinque case. Appointment is discretionary in domestic cases, and they are usually only appointed in high conflict cases due to the increased cost of having another attorney involved. Generally, they are appointed to represent children, though research has demonstrated that the role and exact responsibilities of a child's attorney is less clear due to jurisdictional differences that exist. In Kansas, GALs are referred to as best interests attorneys, meaning that they do not necessarily represent the child's wishes. The American Bar Association defines a best interest attorney as a lawyer who provides independent legal services for the purposes of protecting the child's best interest without being bound by the child's directives or objectives. The GAL's role is to ascertain the best interests of the child and make recommendations to the court based on their investigation. These recommendations will generally carry considerable weight with courts. That means that GALs must be very well educated on child welfare and development and able to implement the strengthening families model in order to support the best possible outcomes for children. In Kansas, GALs are governed by Supreme Court Rule 110A. This rule requires GALs to engage in continuing legal education regarding child development, lists the factors that should be taken into account when conducting an investigation and making recommendations, and requires that the GAL disclose to the court if the child's wishes differ from the recommendations of the GAL. State child welfare agencies also have attorneys that represent their interests. Agencies such as DCF may be represented by the prosecutors that prosecute SINC cases, or they can have private attorneys representing the agency, or both. The role of the agency attorney is not always clear, as prosecutors will often represent the people or the state as opposed to the agency. This can lead to disagreement about whether the attorney or the caseworker is actually speaking for the agency. It can often seem as if the prosecutor in a SINC case and the social workers staffing the case have different goals based on their actions, which further convolute. Judges are neutral decision makers who preside over cases. They are required to make decisions based on the information that is presented to them in court, so they may not always be aware of the full extent of a party's situation. In uncontested litigation where parties co-parent well and work together well, they likely will not be in front of the judge very frequently. In high conflict and contested situations, the parties will likely be in front of the judge more regularly. When discussing the duties of a judge, former United States Supreme Court Justice Benjamin Cardozo once said, "He is to put himself in the position of a wise, affectionate, and careful parent and make provision for the child accordingly." The doctrine of parens patriae, which is the legal authority for a judge to step in to protect those who cannot protect themselves, such as children, is still extremely prevalent in child welfare courts. Litigants may become frustrated during the life of a case that a person who has never met their child will be determining what is in that child's best interests. Although judges are neutral decision makers, their experiences and personal beliefs can impact their decision making. Additionally, judges are compelled to consider the passage of time from a child's perspective, which can have more severe implications in SINC cases. In SINC cases, a judge has two distinct roles: to fulfill the community caretaking function of protecting children and ensure that parents' constitutional rights to parent their child is respected. Social workers and court-appointed special advocates, or CASAs, are not attorneys, but they are still very important to the legal process. Every SINC case will be assigned at least one social worker that works directly with the family to address that family's needs. There are different types of workers depending on the needs of a specific family and the jurisdiction the case is in. Most commonly, there are prevention workers, protective service workers, family support workers, and adoption workers. Social workers are responsible for helping connect families with services such as substance use treatment, mental health treatment, parenting classes, and family therapy. CASAs are volunteers who receive training and are appointed by the court in complex cases to help advocate for the child's best interests. CASAs are usually assigned to SINC cases, but a few counties in Kansas, including Wyandotte County and Johnson County, will appoint them to domestic cases. Social workers have a different code of ethics than attorneys do, and we will explore some of those differences in more depth. Mediators and conciliators are usually attorneys serving as neutral third parties. This means that they aren't representing the parties, but they are trying to facilitate an agreement between them. Mediation is a viable option in domestic cases such as contested custody issues, but it is not an option in SINC cases. Mediation is generally more cost-effective and timely, which makes it more accessible to the populations who use this service. Mediation is also more flexible than litigation, which usually allows the parties to come up with creative solutions that meet the needs of their specific family. Additionally, the rules of evidence that apply to litigation do not apply to mediation, which means that the parties can bring up anything that may be relevant to the issues that they are trying to resolve. Conciliation is a process that is very similar to mediation, except that the conciliator will provide a report to the court detailing what happened if the parties are unable to come to an agreement. It is becoming increasingly common for some sort of alternative dispute resolution to be mandated before a trial is held. Both of these forms of ADR embrace the strengthening families model because it encourages resolution outside of the courtroom and allows for the flexibility to meet the individual needs of a family. Though mediation and conciliation are great tools for family disputes, it is important that those facilitating these services understand that these options do not provide a level playing field for everyone who uses them. One example of this would be a relationship involving domestic violence and/or coercive control. This is another topic explored in this series, and we would encourage you to watch that presentation for a more in-depth discussion of the effects of domestic violence and coercive control on family law. How do all of these actors work together in family court? Comparing contested custody litigation to sync cases is kind of like comparing apples to oranges, but there is a lot of overlap. These two systems are inextricably intertwined, and both can benefit from a model of advocacy that is less trauma-inducing than the current ones. Research has demonstrated that amicable divorces are hard on children, and the more contested the issues are, the more detrimental the effects are. The negative effects of removing children from the home and growing up in foster care are also well documented. We're talking about attorneys' ethical obligations because of the amount of power that they have in these cases, and they should be using it to create the best possible outcome, one that strengthens the families that they're involved with. We can't go back in time, but we can learn from what the research tells us, and we can do better moving forward. We have already mentioned a few of the other topics in this series, but being aware of all of these issues is important because they will be part of your case, and your advocacy can help promote positive outcomes for children and families. Using the Strengthening Families model impacts attorneys' ethical responsibilities because it requires that attorneys are well-versed in social science research. This includes staying up to date on current literature and having a specific concentration of advocating for the best interests of your client over the lifetime of a case, not only advocating in that moment. Ways to do that include promoting stability through continuity of representation and making decisions that decrease trauma and increase family reunifications. In order to fulfill these obligations, attorneys must be able to recognize the issues that a family is facing, such as domestic violence and the impacts of adverse childhood experiences, so that they can advocate for the client and the family's needs appropriately. We are now going to explore what this means in the context of the Kansas Rules of Professional Conduct. As we have previously mentioned, lawyers and social workers have different codes of ethics that they must follow. Before we dive into attorneys' ethical obligations to their clients, it is important to note some of the differences that exist between attorneys and social workers. We have already briefly discussed the limitations of domestic courts as well, and those differences should be kept in mind throughout this presentation. The first area to discuss is confidentiality. There are very few exceptions when a lawyer may disclose confidential information, and it is one of the oldest professional privileges. Social workers, however, must disclose information anytime the duty to the community is greater than their duty to their client. One example of this difference is that social workers have a duty to warn if a client is in danger or has made threats towards another, whereas attorneys have the discretion to disclose this information if they feel that it is appropriate. Loyalty is another example. Attorneys have a singular duty to their client, even when their client's interests differ from that of society. Social workers, on the other hand, must balance child safety and family preservation in decision-making. The Strengthening Families approach lends itself to the social worker's definition of loyalty in this case because the focus is on the family. The last thing we are going to talk about in this section is objectivity. Lawyers have no duty of objectivity. In fact, they are ethically obligated to zealously advocate for their client's interests, regardless of what the opposing party is advocating for. In the alternative, social workers use a variety of tools in an effort to remove subjectivity from the decision-making process. When attorneys and social workers are advocating for the same thing, this difference is likely to not matter. However, particularly in the world of child welfare courts, attorneys will argue that children should be reunited with their parents, and social workers will argue that for one reason or another, reunification is not an option. Both of these parties working together under the Strengthening Families model is important to help make sure that we are working towards the same goal of strengthening families.
Rule 1.3 of the Kansas Rules of Professional Conduct and the Model Rules of Professional Conduct state, "A lawyer shall act with reasonable diligence and promptness in representing a client." The dictionary defines diligence as careful and persistent work or effort. So what does diligence look like? It includes things such as conducting prompt and thorough investigations, responding to emails and phone calls in a timely fashion, and the like. But it also includes advocating for your client based on their strengths. The Strengthening Families approach affects an attorney's obligation to be diligent because it encompasses determining what the family's strengths are, trying to find ways to keep the family together, and understanding how the client's background, including things like adverse childhood experiences, could be impacting the situation they are in now. The American Association of Matrimonial Lawyers takes diligence one step further under Standard 2.23 by stating, "Every lawyer should consider the welfare of children when representing a parent in a custody dispute." Clients may not always be happy with their lawyers or the advice that their lawyer is giving them. It is important to remember that part of being diligent and following your ethical obligations is to make sure your client knows that you are on their side. Recent studies indicate that attorneys are failing in this duty more than any other. Particularly in child welfare cases, where an attorney may be appointed to represent a client, instead of the client being able to choose who represents them, it is important the attorney know how to create a relationship with their client. Research indicates that the following steps can be extremely useful in doing just that: building a relationship with the client, building rapport, establishing loyalty, explaining the hearings, and eliciting and obtaining pertinent information. Rule Point 4 of the Kansas Rules of Professional Conduct and Model Rules of Professional Conduct state, "A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation." Across all areas of law, the most frequent ethical complaints involve an alleged inability to communicate. Most of these complaints fall into issues of failing to return client phone calls or failing to inform clients of important developments in their case. But ethical duties in communication extend beyond these procedural failings. In law school, we are taught to look at legal issues objectively and technically, but in family law litigation, this is not a realistic perspective to have. Family law involves intense emotions and personal issues, and a lawyer must be knowledgeable about how to effectively communicate under these circumstances. Lawyers have a duty to ensure that clients are making informed decisions, and this is difficult when clients are emotional. Some lawyers may decide to view a client's emotions as a distraction from the legal issues at hand, but this is contrary to the practice of upholding the Strengthening Families model. It is imperative to improving the lives of children that parents are uplifted and provided resources in order to manage their difficulties. For example, a lawyer who sees a client's emotions as a burden may not pick up on the fact that the client may need therapy in order to be the best parent they can and reduce the childhood trauma that comes with divorce or a sink case. A client may have trauma around divorce or child in need of care cases because they are a child of divorce or foster care. Their reasons for getting a divorce might be sensitive and hard to share. They may have a distrust of the legal system based on prior bad experiences or a historical distrust of the legal system in their community. It may be their first time talking to a lawyer, and it may feel very vulnerable. If a lawyer has not navigated these emotions, she cannot ensure that the legal information she is communicating will help her client come to any informed decisions. Additionally, an attorney who chooses to focus on what is legally relevant rather than emotionally relevant may end up coming across as condescending to a client, such as explaining in depth the divorce process to a client who has been through a divorce before. Another example is preparing a client for court who is a domestic violence survivor. The client may have significant anxiety about seeing her abuser in court and needs to be walked through the process a few times before a hearing. Treating this client like a client without a background of trauma may cause the client to have a breakdown in court or not show up at all. It is also important to understand a client's cultural background and trauma they have been through in order to best communicate. For example, during an initial interview, a client may avoid eye contact and give short answers to broad questions. An attorney who is not informed of the client's cultural background may assume the client is lying about something, when in reality they come from a culture where avoiding eye contact is a sign of respect and it is frowned upon to overshare with strangers. This client may choose not to share their culture at all, but simply knowing that it is a possibility that the client's behavior is due to cultural differences is a solid start to building the relationship. Dealing with your client's expectations falls primarily under an attorney's ethical obligation of communication. Clients in family law situations, whether it is child welfare litigation or contested custody, are usually going through a very tumultuous period in their life. This particular season may be compounded by past experiences as well. It is imperative that attorneys take the time to talk through the situation with their client so that they can accurately and adequately understand and address the expectations their clients have. Many clients will feel that they have been wronged and be frustrated by the magnifying glass placed on their lives, particularly in sink and child welfare litigation. Further, they are likely to be seeking immediate relief. It is essential that attorneys explain the limits of the legal system and any potential bars or complications to the client getting what they want. Being transparent with your client about statutes and case law is another tool that you can give your clients to help them fully understand the process they are participating in. A strengthening families approach to managing your clients' expectations can actually change your perspective of difficult clients. Rule 6.A of the Kansas Rules of Professional Conduct and Model Rules of Professional Conduct state, "A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B." Paragraph B then proceeds to list all of the situations where you are permitted to disclose information, and paragraph C then states that a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of information relating to the representation of a client. Lawyers are typically only permitted to share confidential information if they believe it will prevent harm to the client or someone else. Using a strengthening families approach affects confidentiality because the relationship will be established that allows the client to be completely open and honest so that the attorney can advocate to the fullest possible extent. It is important that clients feel attorneys are focusing on helping clients instead of judging them. This obligation is rooted in the beginning of the relationship and encompasses explaining the difference between confidentiality and attorney-client privilege, and that both prevent the attorney from being able to share information about the case. Working with an attorney is often an invasive experience, as attorneys are probing into their clients' innermost worlds. It is important to explain to your client why all of the information you are asking for is relevant and pertinent. Rule Point 1 of the Kansas Rules of Professional Conduct and Model Rules of Professional Conduct require that attorneys have the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. There are obvious requirements to follow this rule. Stay up to date on the law, keep up with deadlines, and proofread any agreements carefully. But there are a few less obvious factors to keep in mind when working towards using a strengthening families approach. First, an attorney needs to be aware of the social science surrounding divorce. Being able to back up advice to a reluctant client by showing them solid research could be an effective way to manage client expectations and reduce family trauma. An attorney representing a parent in a sync case can use their knowledge on social science to best understand what effects the litigation will have on children. For example, in Jane's scenario, it would be very important for an attorney to understand what concrete resources Jane needs to recover, as this is a protective factor. The lawyer who is aware of these resources can use them to help advocate to the judge for an evidence-based approach. An attorney should also be knowledgeable of human emotions and how to navigate them, particularly when they are dealing with clients they don't always see eye to eye with. Cross-cultural lawyering ties in nicely with the language of Rule 1.1. An attorney needs knowledge of how his client's culture will affect the representation, must have the skills to navigate this cultural difference, and must be thorough with researching the ways a client's culture intersects with the issue at hand. For example, let's consider Jane's situation again, but assume she is Black. 65% of social workers are white, 85% of lawyers are white, and 73% of judges are white. It is very likely that the people making decisions about her family are not the same race and/or culture as her. Research shows that due to the criminal justice system's long and systemic discrimination against Black people tend to be distrustful of all legal institutions, including civil justice. Jane's white attorney may label her as a difficult client for choosing not to disclose all relevant information about her substance abuse and her children, when in reality, cultural differences make Jane reluctant to disclose everything. Due to a disproportionate number of Black children in foster care, perhaps Jane has a friend or family member who has had their children taken away regardless of compliance with attorneys and social workers, therefore increasing her distrust of the actors in the legal system. Now let's shift gears into another factor that can affect competence. Vicarious trauma is the experience of a professional developing and reporting personal symptoms of trauma as a result of responding to traumatized clients. The symptoms do not always rise to the diagnostic level of PTSD, but can still interfere with day-to-day life. Symptoms include a decreased sense of energy, no time for oneself, increased disconnection from loved ones, social withdrawal, increased sensitivity to violence, threat, or fear, a generalized sense of despair and hopelessness, increased fears for the safety of oneself and loved ones, avoidance of violent stimuli in the media, difficulty listening to clients' accounts of events, and emotional numbing and disassociation. An attorney is especially vulnerable to vicarious trauma if they have experienced trauma themselves. There is no question on whether family law attorneys will be exposed to vicarious trauma or secondary trauma. The question is how the legal profession deals with the effects. A 2017 study compared vicarious trauma in mental health professionals and attorneys and found that while both groups were exposed to vicarious trauma, mental health professionals were better equipped to deal with the trauma due to trauma-specific training and access to peer support. So why does vicarious trauma matter? If an attorney's vicarious trauma forces them to become disconnected and hopeless, they are not in a place to best help their clients. If an attorney has not learned to manage their own emotional and psychological responses to clients, they will struggle to provide competent representation. The issue of compassion fatigue can also arise. an attorney being numb to very emotional issues due to a fatigue that comes from dedicating so much time and energy to helping others. An attorney may choose to overlook or minimize a client's traumatic experience because the attorney simply does not have the emotional capacity to process it. We will discuss later in the presentation where to find support for these issues, and these support systems could help an attorney come up with methods of self-care. Self-care is easier said than done, which is why support services are vital to maintaining mental health. Examples of daily self-care include getting 7 to 8 hours of sleep, eating healthy foods, exercising, taking up positive hobbies, reducing alcohol consumption, maintaining connections with friends and family, and participating in spiritual activities. All of these things may be pretty difficult for a lawyer experiencing depression or anxiety or burnout, but taking it a day at a time and not putting the burden only on yourself to deal with this will help over time. It is not an easy process, but it is doable, and taking care of yourself will help you take care of your clients. The Kansas Lawyers Assistance Program is a great resource for managing these issues, and we will discuss this more in detail later in the presentation. Now let's move on to guardian ad litem ethics. There are many schools of thoughts on GAL ethics, but the goal of this presentation is to view the ethics in terms of the strengthening families model. A GAL in Kansas is a best interest attorney, and thus has different obligations than a child's attorney. A best interest attorney is not bound to the same confidentiality ethics, as it is their duty to report all relevant information to the court. Making recommendations that are in the best interest of the child means that a GAL must be familiar with child development and the strengthening families model. The goal of the recommendations should be to reduce childhood trauma and to do so by uplifting the family system. In Kansas, there are 18 factors to be considered by judges and GALs when determining the best interest of the child. Some of these factors include each parent's role and involvement with the child before and after separation, the child's preferences, the emotional and physical needs of the child, the presence of domestic violence, the willingness of each parent to respect and appreciate the bond between the child and the other parent, the location of the child's school, and the ability of the parents to communicate. The strengthening families model impacts the evaluation of these factors because each family should be viewed based on their strengths rather than their weaknesses. A 1997 study, introduced on the next slide, surveyed child psychologists and asked them to rank different best interests of the child factors, which provides us with an excellent view of how strict legal criteria actually manifests from a psychology perspective. This study surveyed 88 child psychologists and custody evaluators and asked them to rate on a scale from 1 to 7, 1 being irrelevant and 7 being essential, 60 different factors that play into the best interest determinations. The tables on this slide and the next show the means of the responses for each factor. The factors in this chart loosely correspond with some of the Kansas best interest of the child statutory factors discussed on the previous slide. One of the purposes of including this chart in a presentation on legal ethics is to provide an example of how staying informed on social science can impact our ethical decision-making. For example, each parent's financial sufficiency is closer to irrelevant than essential, according to child psychologists. A legal actor who is not aware of similar research may place significant weight on poverty when deciding the best interests of the child, when in reality there are many other factors that require more attention. An attorney could also act ethically by refraining from bringing up an opposing party's poverty when advocating for their client's child's best interest. Now let's look at these factors in relation to our hypothetical of Jane. Recall that her primary struggle in providing for her children was a dependency on substances. In this study, substance abuse is a factor ranked at 5.85. The emotional needs of the child is ranked at 6.11. Research shows that separating a child from their parents has a significant impact on their emotional well-being and needs. Compared to children not in foster care, children in foster care are 5 times as likely to have anxiety, 6 times as likely to have behavioral problems, and 7 times as likely to have depression. Now, a caveat to these statistics is that many children in foster care experience trauma before entering state custody, which could account for these high rates of mental health issues. But also recall that Jane's substance abuse was the primary reason for removing her children. The best interests of Jane's children are not met by putting them in foster care, and it is imperative that a strengthening families approach be adopted in order to reduce the likelihood of childhood trauma. Attorneys evaluate risk and reward when determining how to best advocate for their clients' interests. Under the strengthening families model, working to prevent unnecessary family separations is rooted in an ethical argument when risk is prioritized because we have an obligation to avoid the worst possible risk. With that, we also have an obligation and the ability to address issues in a way that does the least amount of harm to the family. Using this model allows us to better identify issues and understand how we can provide the family with help and support. Additionally, when you change the way you work with your clients, it will change your ability to handle difficult cases, increase empathy, and you'll likely start to apply this model of thinking in your own life. People don't tend to get involved with the court system because everything is going well. There is usually one or more major issues impacting a family's ability to function when lawyers get involved. Viewing a case through that lens allows the attorney to objectively evaluate situational aspects that would influence their client's ability to navigate the difficult circumstances they are in. This is especially important when the situation involves domestic violence or coercive control, because trauma makes maintaining a relationship with the abuser more difficult and dangerous. You also might have a client who wants 50-50 parenting time and will not be happy until that occurs. However, there are many practical considerations, such as the distance between the parent's home and work schedules, that prevent 50-50 from being feasible. It is exponentially more challenging when there has been coercive control in the relationship between the parents. Another example that attorneys will commonly face is allegations of parental alienation. Although the research does not empirically support the idea, one parent will often allege alienation in an attempt to regain control of some kind over the other parent. Another crucial aspect of client-centered lawyering in family law is differentiating between poverty and neglect. Although many state statutes, Kansas included, specifically state that being unable to provide financially for a child is not grounds to remove them from the home, a number of situations that bring children into state custody can be traced back to poverty issues. It will take changes on a societal level to truly fix these issues, but attorneys can still make a difference by drawing this distinction early and often in the representation of their clients. Rarely is there a winner in family law, but the strengthening families model can help families move forward. The model that we are proposing focuses on providing supports for these families instead of separating them. To wrap things up, let's talk about support. The Kansas Lawyers Assistance Program, or KLAP, is an excellent resource for lawyers experiencing vicarious trauma or burnout. Recall that a competent lawyer practices self-care and reaches out for help when needed in order to best serve their client. KLAP can refer attorneys to therapy and treatment and even offers several free therapy sessions. There are peer mentoring groups, support groups, and resiliency groups. Recall that social workers are able to manage vicarious trauma more effectively than attorneys, in part because they have peer support. Now, if an attorney is facing an ethical dilemma outside of their own self-care and mental health, the ethical rules allow the attorney to seek advice from a colleague by only giving as much information necessary to explain the ethical dilemma. Thank you so much for watching. Please visit the Children and Family Law Center website to view our other presentations on child welfare.